Bismillahirrahmanirrahim, legal eagles, luminaries, and learners. Welcome from Oxford. Today, we have with us Judge Muhammad Amir Munir, who is Additional District and Sessions Judge. He has been a judge for a long period of time, and he is also pursuing his PhD at International Islamic University in Islamabad. And today, Judge Munir will talk about new approaches to judgment writing for the litigant's perspective. Over to you, Mr. Munir.
Thank you, Dr. Abbasi. I am grateful for the invite from the Forum of Global Institute of Law. Can I talk in Urdu as well, or it will be an
Yes,
English session?
we are bilingual, and if you feel like talking in Punjabi and Saraiki, please feel free.
That's great. I would love to do that. So, okay, let me introduce initially in English, then I will come to Urdu and other Punjabi language. After saying thank to my host, Dr. Zubair Abbasi, I would like to introduce the topic in very brief. I have selected a topic, new approaches to judgment writing for the litigant. So the purpose of this topic for me is to recall the prospective end users of a judgment, to explain the modern trends and approaches in writing judgments and orders, and to know a part of that some therapeutic jurisprudence in judgment writing for the litigants. On these three lines, we will be studying for the next 30 minutes. We will share certain ideas about this, particularly with reference to Pakistani jurisprudence of writing judgments and orders. Because I myself, I am a judge since last 20 or 21 years and working in the trial courts of District of Province Punjab. So I would like also to share some of my own experience in this regard, that how the litigants who appear before a judge or a court feel deprived out of the final outcome of court, to which we call a judgment or an order. So that's why I tried to write something on this topic. I have been teaching this topic in the Federal Judicial Academy, Islamabad, and also I have given certain lectures on this topic to some international fora, including professors from America, Australia, and England. And this topic is really of great interest to these institutions, particularly of judicial training for our own judges. Now, my strategy will be that I will be telling you how I teach this subject to the judges in the judicial academies. And this way we will keep on moving forward slide to slide, and we will keep on discussing those ideas. And at the end, if any questions are there, or Dr. Saab, you or any other audience which will be joining us, they may ask anything, and we will be discussing it like a seminar or the mutual discussion thing to understand the idea or the question, and then I will try to say something about what I feel as an answer to that query. तो इसको उर्दू में थोड़ी सी हम बात कर रहे थे डॉक्टर साहब, ये फैसला उर्दू में हम इसे कहेंगे अदालती फैसला साजी, और इसका जो सब टॉपिक मैंने बनाया है वो है कि अवाम के लिए या जो हमारे साइलीन जो हमारे सामने आते हैं उनके लिए फैसला साजी कैसे होनी चाहिए अदालतों की तरफ से, और इसी में हम इस सारी बात का जिक्र करेंगे। तो सबसे पहला क्वेश्चन जो किसी शख्स से भी पूछा जाता है जब हम हमारे सामने जजेस हों, वकला हो या साइलीन हो, वी आस्क देम दैट व्हाट इज ए जजमेंट, जजमेंट है क्या एक्चुअली। तो जो लिटरेचर हम इस जजमेंट राइटिंग पे पढ़ते हैं दैट कंक्लूड्स दिस क्वेश्चन इन टर्म्स दैट ए जजमेंट इज अ जुडिशियल कम्युनिकेशन। जज जब भी कोई काम करता है या करती है, अगर वो लेडी जज है, फीमेल जज है, whatever is put before a judge in the case, in a trial, in a petition, in a bail matter, or any other proceeding where you need some final order from the judge, after processing the whole through the procedure of law and following the civil or criminal or family procedure, if I talk of particular fields of law, we reach at a conclusion. And this conclusion is terminated in the form of a judgment or an order. Both ways, this is to communicate that how a judge actually considered the whole material before the judge, how the judge has reached at a particular decision. Judge has to provide certain reasons to reach that decision, so that when a person in whose favor or against whom that order is passed or that judgment is made, that person or that parties can understand that why is this judgment, why is this order either in my favor or against me. So this is actually judicial communication, and this is, this is the final product of the court system. All the courts, even throughout the world, they work to produce this final product, which is called a judgment. So it is very, very important final product of a court for the litigants, for the, you can say, the public, for the media, for the teachers, for the researchers. So anyone or everyone who is interested in the justice system, they actually read our judgments, our orders, to see how smart is our judicial system, how much it is catering to the constitutional and legal rights of the people of the nation or the state they serve. And this way they can also try to make some informed decisions, policy decisions for future change of laws or amendment into the laws, or to bring some new laws. And this becomes a great, you can say, need assessment for all those people who are interested to study the judicial system of a country. So the judgment is so much crucial for any justice system. I want to say this thing. So it is judicial communication not only for the parties, but it also leads to all other stakeholders. Even an economist is interested to know that why the judges or a judge or a group of judges or a court or the Supreme Court or the High Court has reached to a particular decision, because our decisions ultimately affect, according to our own levels, the economy. For example, you already understand the Pakistan Steel Mills case. You already understand number of other decisions. Even if a rape case is decided, it affects the quality of a country and its justice system. So this communication by a court is firstly important for the litigant, to the both parties, to the state, and then to all the legal stakeholders. And when you are living in a community of nation, the people from, international organizations, people from other countries, the investors, the businessmen, the businesswomen, all such who are interested to look towards that country, they wanted to know that how its justice system is working, whether we need to invest into this country or not. So the judgments are so important in this regard, and its communication properly for everyone is also very important. Now, as I told you that there are so many stakeholders which need to understand what the judge said about a particular list before him or her. But here my focus, or the focus of this session, will be or is towards the litigant, toward the party, to a list. Why it is so? Because in our Pakistani legal and judicial culture, we have certain limitations about the way we communicate our judgments to the parties, to the litigants, to the audience, and that, affects sometimes positively, sometimes negatively to our audience. And the and the main audience is parties in this seminar, I mean for this seminar. And then I will be telling you that why they have sometimes negative impact on them if we are not able to communicate the order properly. So when I teach judges about the judgment writing, I always ask them that why and for whom you are writing this order. I mean, your job is to write judgments and orders. You reach at a conclusion after going through the whole list. So when we ask the question, there are so many answers. Sometimes they generally say that it is for the parties, but then they say so many other things. As I told you earlier, that all other stakeholders, they name, for example, the media. Sometimes they say for the superior courts, sometimes they say okay, it's for general public, sometimes for researchers, and sometime for the international audience as well. But the main thing is that we we write the judgments for the parties to a case which are our main audience. It is also important to reach at this conclusion that every other stakeholders comes after that party. It is a party that brought the case or the list before the court for a judicial resolution. Because once they are unable to resolve the matter outside the court or through use of any mediation, you can say alternative dispute resolution methods, or when the parties are unable to come to a conclusion by their own, so then they move to the court formally. So our decisions are formal determination of that very list, so that when the decision is made, when the judgment is given, it becomes enforceable. Now, no party can say, I will not accept this decision, because this is a formal justice system. And we have, and for that very reason, we also need to write the judgment very carefully, so that the litigant, so that the party, and so that the superior courts can understand that why I, as a trial judge, or why as a motion judge, I have decided this either in favor of A party or the B party. So taking from this, we can move then to higher levels. So when our first focus is parties, then we need to lower down the way we write our judgment. Here, the lower down never means the lower down of the quality of a judgment. I am not talking of this lowering down of the writing of a judgment. I am talking of the sense, the way we communicate the judgment to a party. We need to come it to we need to bring it down to the level of the audience. For example, if audience before me, they are you can say the children of like 15 years of age. So when I will communicate with them, whether I can write the same style of judgment which I generally wrote for other major parties to the list, or to a civil suit, or to a criminal litigation. This is the general archaic and ordinary trend in our country and perhaps around the globe, that judgments are written mostly in the form of legal language. We will be discussing this for in upcoming slide, that how we can bring down the way we communicate with the parties up to the level that the parties are the audience which can understand that very judgment or order. Now, this slide is taken from Justice Fazal Karim's Judicial Review of Public Actions. It is the second edition of the book, which is recently published, and they have concluded, I mean, the Honorable Lordship has concluded that the judges should focus towards the parties while writing their judgments. Now, when we go to read international literature on judgment writing, there is a very beautiful article. It is little old article, but it concludes so many things even for Pakistani literature, Pakistani judges. It is authored by Lord New Berger of the United Kingdom. He was a Chief Justice of the United Kingdom in the past. He addressed first Bailey lecture, and his topic was no judgment, no justice. So in that article, Lord New Berger has concluded that every judgment needs to be sufficiently well written. It is again the same thing. A well written judgment means if any person who is an ordinary person reads it, he or she can understand. Right? It also says that it should speak to the public in a clear tone, in a clear manner. So it means the level of the writing, whether it is in Urdu, whether it is in English, in French, in Spanish, or whatever language you write, it should be easily understandable to the public. So when we use the word public, it means its level of writing should be simple. So we will come forward. I mean, in upcoming slide, we will also see this how it is relevant to Pakistan, to enable interested and reasonably intelligent non-lawyers to understand who the parties were, what the case was about, what the disputed issues were. So you can understand here again, you see that the Lord New Berger is, I mean, he belonged to England. He lived in a country where everyone speaks English. Their mother tongue is English, they speak English, and they write in English. But still, they want that the judgment should be of, written in such a way where a non-lawyer can also understand that. And then what the decision the judge reached. So it should be logical. A person who is reading a book, he or she starts from page one, and when he or she reaches at the last page, it should all be, you know, appealing to mind that if these were the facts, this should have been the decision. There may be something of the, you can say, uh, you may differ from the decision a judge reached in very particular fact, but it is the general people, it is a general understanding that in those given facts one should have reached at that conclusion, because sometimes judgments are given by the judges and they are set aside by the honorable superior courts. They disagree with the reasoning a judge makes. So this is another thing. It is actually not the topic of my judgment that why appeal courts set aside a judgment of a lower court or a trial court. We will discuss this in some future, you can say, session if it is possible. Otherwise, here I wanted to say that it should be very simple, simply written the same. Then then the Lord New Berger also suggests that the simplicity of judgment should never mean that it should be to avoid or to, you can say, to bypass certain legal principles. The judgment has to mention those legal principles, but the only thing is that they have to be explained in simple language as well for the reader. The reader here means the litigant. So for example, if we say, we use the word mutatis mutandis. So if I write this word in my judgment, maybe the litigant is unable to understand, even if he or she is very well conversant in English. Maybe this legal jargon is not available in his or her memory. He or she needs to go to Google the term or to see some dictionary. The modern trend of writing judgment says don't do this. Write simply. So if I use the word mutatis mutandis, I can then put a bracket in front of that and then write that it means as it is. I am quoting the paragraph below as I have read. So you can translate it in any way which is simply understood by the reader of the judgment. Now you see this picture. I like this because it says that if the judgments or the orders are not well written, they are non-speaking, or when the people are unable to understand, then they must be having this face, this expression, and this expression you can feel that although I have decided a case, for example, I have passed a life sentence upon you, or I have decided to pass a death sentence. As in Pakistan, there are many offenses where we can pass death sentence. For example, in rape cases, in narcotics cases, in murder cases, or in terrorism cases, to name a few. So if the person whom I have decided to hang through my judgment, if he or she will be having this face after reading the judgment, you can imagine the trust level on the court system, on the justice system of that country. So we don't want this picture when we decide and when we announce our judgment to the litigant, to the audience, to the public. They should be welcoming. They may disagree, but this face should not be of the litigants when they read the judgment, or when they hear the order, or when they hear the sentence, because this shows the confusion in the mind of the person. And the judges should be very careful that when they craft their judgments, they must craft the judgments and orders in a way where they can clarify their reasoning. And for this, there is a lot of understanding, there is a lot of material available online where you can read that how to write a clear cut judgment, what are the arts and sciences to do that. Even the judicial academies are working on that, and they are teaching judges how to remove the clouds, how to remove the mist, how to remove this fog when they write some order or judgment. Now, if we go to elements of a good judgment, I have only summarized them for the reason that if there are some aspirant lawyers to become judges, or the new judges who have just joined the judiciary to start their work, this slide will help them to structure their judgment. The structuring shows, I mean, this is not my structuring, this is, you can say, the sum of lot of literature on judgment writing. It says that a well-structured judgment starts with opening of facts. It discusses the issues or the point for determination. Point for determination are those points on which the judges ultimately, deliberate. They create a discourse after the taking evidence of the parties, and the and to develop the focus of the litigants, that on what particular points they have to bring evidence in the court. When we put the plaint along with the written statement, then we formulate these points. Or for criminal law, when the prosecution puts his case, then we formulate point for determination, and the parties then remain, on focus, that because out of the divergent pleadings of the parties, these are the points which the judge needs to understand for its final, I mean the court, for its final decision. And this is not the judge's own wish to seek evidence. It is actually how the parties put their case before the court. So if one says that I have purchased this vehicle from the market and it is in my name, so I own it, the other party will say no. This, yes, they say yes, the car was purchased by this man or this woman or this buyer, but then after transferring of the ownership to this person, he or she has sold this to me. So the judge will formulate a question. He or she will formulate a point for determination or formulate an issue. He or she will write that whether this vehicle was originally in the name of Mr. or Miss A, whereafter it was sold to Miss or Mr. B. Question mark. And then parties will bring their evidence, and then judge will, bring, after looking into the whole evidence, the judge will look at the law. He or she will analyze that in these given facts, if this will be the law, then whether A has proved its case. If so, the decision will be in that person's favor. So this is how we move on the judgments. And after our findings, we give our conclusion that the suit is decreed or dismissed. Now, the next point is that the language of the judgment should be very, very simple. If you do not write simple language, it will again, bring that face to a person. Although reasoning is okay, your legal jargon for the lawyers or for the superior court judges, they will appreciate it that you have quoted all the relevant law. But when the person for whom you have written the judgment is unable to understand that language, maybe they will not quickly grasp the idea you have discussed there. So it should not be a piece of literature. Generally, sometimes you may write as a literary judgment, but it should not be every time. It should be very simple, plain, and of ordinary mode of writing in the language you chose to write. Its length should be appropriate. Judges, sometimes when I was in the Federal Judicial Academy, some new judge asked me that how much pages are required to write a judgment in a murder case. I said, you may write 5 pages, you may write 10 pages, you may write 15 pages. Then he said, sir, if I will write a judgment in 5 pages, High Court or the Supreme Court will mind it that how summarily you have decided a murder case. My answer was that it depends on facts to facts. Every case has its own facts, and you have to write the judgment keeping in view the evidence available and what was the point for determination before you. So maybe a very good judgment in a murder case may end in fifth page. No need to go for 10 or 20 pages. I'm not to compete with my fellow judge who is writing 30-page judgment. Maybe the facts and circumstances in that very case required that it should be of that length. He needs to discuss more evidence. He needs to discuss more law. He need to discuss more, you can say, the available proposition. So when that person, he or she is writing so much pages, it is not that I have also to write 30 pages for a murder case. I have to decide my own length of the judgment after looking into the facts. It comes with practice. So sometimes I used to write lengthy judgment. Sometimes I say no, I should reduce it. So if I write first draft of maybe 10 pages, then when I read the draft again, I decide, okay, no, it's some pages, some paragraphs I can simply omit by using some single liners or by even simply omitting them. So slowly you will learn out of it. With respect to the language or communication, I again said that the language should be litigant oriented. It should show the voice of the litigant. It's very important. When you decide through a judgment against a person, you know, he or she at the very instant want to know that whether his or her views are available in the judgment, whether they have been taken due notice by the court, whether the judge has analyzed the facts, the law, the evidence in the light of his or her own discussions about his case or her case. So this is very, very, very important for the judges. So if you are to decide a case against party A, you need to bring most of his or her case in your judgment, so that when he or she will see that the judgment is against me, then they will look at that my there were 4 points which I wanted to put before the judge, and yes, the judge has discussed my point one and answered, two answered, three answered, four answered. The judgment will be much appreciated. Although the right to appeal, right to challenge, right to file a revision or appeal or review, whatever you call it under the law, it is always there. But the satisfaction of the party will be that his or her point was discussed, was taken up by the judge, was deliberated. But then they will go to appellate court for the reasons that either they have a right of appeal, that is a statutory right, they can always challenge a judgment. And then they will say to the appellate court, to the higher forum, whatever it may name, I mean, you name it, Supreme Court or appellate court or whatever, they say, sir, the judge has discussed all my points. I am satisfied that discussion is there. But the learned trial judge, the learned lower judge, could not understand the law, keeping into the facts and circumstances brought on record by the parties. So here it is a job of the appellate court to see whether the judge rightly concluded or wrongly concluded. A judgment may be right or wrong. The point is that it should not be malafidely given judgment. It should not be given on some ulterior motives. It should not be given on some other considerations. Because I am a human being. All judges are human beings, and mistake can be done, can be made, not intentionally, but unintentionally. It is all human. When you will write a judgment, the judgment will speaks itself, that whether it is written with all due effort put into it by the judge, whether the judge has examined all the file, all the pages, all the lines, whether the judge has gone through the arguments which parties raised before the court, that how to read this available evidence and how to understand the law on the point and how to correlate the two to decide whether they can work like this, then this job done by the judge is called judging. And judges do this judging in every day, in every case, in every moment. They are doing judging for different dimensions, and they do it. So the voice of the party should be reflected. And the last one I have made is style. The style of a judgment can be different for every person. You may, I mean, you may decide that I have to start from the writing simple facts first, and then you will think that I have to write some law on the point, or then I have to do some other thing before I start actual analysis of the issues and marshalling of the facts. So style of writing judgments is always different with different judges. We cannot fix one standard model in this regard, and it is good for diversity purposes. Because if you say, Mr. Amir Munir, you have to write a judgment in this very fit model, fit frame, it will, block my mind. Maybe I have to use a different road to reach to the same decision. So if there will be a fit frame like this, maybe it will be difficult for me to reach to that, because my grooming, my knowledge, my experience, my way of doing things will be different from the neighboring judge or from an appellate court judge. So this is by practice that how you adopt the style. However, in the judicial academies, we do one thing. We train judges that at least you have to structure your judgment on the above given points. Some points are by the law. Law says that you have to do this, 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 this. But your way to approach those points may be different. So the judgment writing chapters are available in the Criminal Procedure Code in Pakistan. They are available in Civil Procedure Code in Pakistan. Family law also says something about judgments. Maybe the rent law, maybe some other laws. They also prescribe a particular way of writing the judgment. Maybe some guidance is there, but general guidance is in CPC or the CRPC. I mean the Civil Procedure Code and the Criminal Procedure Code. So much guidance is available, and other guidance is from the honorable superior courts when they interpreted those provisions of these two procedural codes, that how judgment should be written. There are a lot of judgments. Now, if we see the criticism of the judgment, it is again collected from various judgments, various articles, newspaper articles, writing of the, you can say, the critiques of the courts and justice system, and the conference papers presented in international judicial conferences in Pakistan and abroad. I have seen that there are 4 or 5 major criticisms. They are inelegant of their length. I already discussed, because when you expand the length of the judgment, it starts becoming confusing. You build a case, and then when you start writing on that very point, I mean too much, maybe your reasoning is now losing the ground. Maybe you are entering into another domain where you don't want to conclude. So it should be smart enough. Language is poor. Nowadays, it is a great criticism on the judgments of courts. I don't know, I am talking of Pakistan. A lot of criticism is there by the honorable superior courts. Even I am also working as an appellate court nowadays since last 4 or 5 years. I may be doing the same, poor language. This may be decided by my superior courts. But as far as I am concerned, I am the first appellate court now. I see the judgments written by some of our colleagues at the civil judges level or the magistrates level. Sometimes I feel that those judges need some training, some more grooming. It is not their fault. It is not their fault. I am repeating it, because we have inducted those judges to work as a judge or a magistrate or a civil judge or a family judge. When we have decided, I mean, when the judiciary has decided that this person, this woman judge or a man judge should sit as a family judge or a civil judge, then it is the responsibility of the judiciary itself, of the judicial training institutions, that they should train that person to be a good judgment writer. And if they will not do it, the responsibility cannot be shifted to the judge only. Okay, we can deliberate on this point at some other session, but I am simply concluding it. So the judgments are sometimes archaic style. They are law focusing. And then again, when they focused law too much, then they missed the diversity issue. Then they miss the litigant standing before the court. Then they miss the social context, the society. So simply writing in legal jargon is not required in judgment writing nowadays. You need to make your judgment relevant. Judges should remain relevant to the society. So if there is a change in the society, for example, in even this pandemic days, if the judges must be asking everyone should stand before me, the witness should be here, the accused should be here, the parties should be here, the advocate should be in this room, and then I will move forward, I think time has gone forward from this. We need to change our approach. For example, now I am delivering my speech, my presentation through this Zoom social media platform. Otherwise, it seems to be a drama, that what I am talking, it may not be reality. But whoever is listening to my session now, he or she will be believing that I am teaching a practical thing. I am a judge, I am a judicial officer, and I am talking to you in real terms, in real time. No matter it's AM at your side or PM at my side, no problem. So this is the way we need to understand this criticism to improve our judgment writing. Now, if you read the blue line, it says foreign language as a medium. This is a great criticism with respect to the judgments written in the courts in those countries which were earlier on were governed by the colonial regimes. So as we remained under the British rule for almost 90 years until 1947, the legacy of the British still continues. I don't understand that after 74 years, this is the 74th year Pakistan just reached. I congratulate to all Pakistanis that we have completed 74 years. But as a judge, as a judicial officer, when I see this judgment writing side, I still see the British legacy continuing as far as the medium of language is concerned. I'm not talking of the negative points of British legacy. I mean, the laws are there, the judges are there, the judiciaries are there. They are not negative, developments in this society due to the, arrival of the British. They are okay. Judges are there. They were working under the British laws. But as far as the means of the language as a means of communication is concerned, it is now becoming a matter of criticism because the people for whom we write judgments, people for whom we are sitting in the courts, people who pay taxes for the salary of the judges, people who pay taxes for the judicial system, people who pay taxes for a good quality smart justice system, they say that I am or we are unable to understand what the judge has written about me or about ourselves because I need again a medium, again an assistance from a person or a machine. You can say the Google Translator to tell that what the judge said to them, said for them, because the order has ultimately to be executed. If I say I am going to, handcuff you, you say, sir, okay, just do. My hand is there. Just handcuff me. But my question to you is that tell me the reason in my own language. I don't understand English. I don't understand even Urdu. I speak Saraiki or I speak Blochi or I speak Pashtun. I speak Dari. I speak Sindhi. Please don't tell me in English. I don't understand. Please tell me in my language. And sir, Dr. Zubair sir, you will be interesting to, it will be interesting for you to know that when I was delivering lectures in the Federal Judicial Academy, I organized a mock trial for the judges. They were judges from all over Pakistan and Azad Kashmir. I said to a Sindhi judge, please come on the rostrum and sit as a judge. I put a proposition before the whole audience, and then I said to that presiding judge, who was a Sindhi judge, that you have to announce the judgment in Sindhi language. You will not say anything in English or Urdu or Punjabi or whatever. So when the judge announced the judgment, I said, okay, all the Sindhi judges will remain silent. They will not be part of this mock trial. So there were, for example, 15 other judges from Punjab, from Balochistan, from KP, from Azad Kashmir. I said, now tell me what was the decision. And they were looking at each other. And they were looking at the judge and they were looking at me. They say, sir, we don't understand this thing, what the judge said. Then I asked them, when you decide judgments and you write your decision in English language, how a person who is totally illiterate, who lives in a village, a far from village from a developed city, for example, 100 kilometers away from Lahore, and a judge in Lahore says, you will be hanged till your death. You will be hanged by neck till your death. And these are the reasons. He will say, okay, just hang me, no problem, just hang me. But I am unable to understand why I am going to be hanged. So this is the point which I want to make understood to all my audience, to the judges of this country, that kindly change yourself to consider at a first level of writing simple English, and then at second level to start writing judgments in your own, your in the language of the court, which is Urdu. So we will talk a little bit afterwards. So Language of the court, I say it's a communication. It's not mother tongue of everyone in Pakistan. I mean, Urdu is not the mother tongue of everyone. It is Punjabi or Sindhi or Balochi or Dari or Pashtun or whatever. All these languages are mother tongue of their own, people. But as far as the language of the court is concerned, for trial courts, I mean, even if I am trying a murder trial, the language of the court is Urdu. I don't know why the system of writing the whole in English is still there. I consider that it should be for the parliament at national level if they want to change the code of criminal procedure, or for the provincial legislative assembly in each province to consider to change the law so that now there is no need to write the whole thing in English language. The party, I mean, the whole evidence is recorded in English and then translations are made in Urdu. Although the law requires that it should be written in the language which is uttered by the witness and then translated into English. And we always keep, make two copies of the whole proceedings, one in Urdu, one in English, for the murder trial. This practice is consuming much of time of the judge as well as the court staff. So 74 years from 1947, and we are still focusing hard on English language. While all the judges from the trial court up to the Supreme Court of Pakistan, the Honorable Supreme Court, all are now sons and daughters of the soil. They understand the national language, they understand the local languages of their own respective provinces. So we need to change on it. So language and dignity, tone and tenor. I will deliberate something about this development in our country, and it is very good development. Doctor, you will also appreciate this thing that sometime the language of the judgments were offensive. Even the language of the law was offensive. The attitude of the law and the judgments was indifferent toward different classes, minorities, and differently abled. There was bias and discriminatory words used in the judgments, in the law, and I will quote some examples in upcoming slides. There was gender discrimination. You must be knowing the recent example of the Sialkot incident. A woman was, raped, and then from certain circles it was said that why you are out at night. So these are the things which, I am, because I am a serving judicial officer, I cannot talk so much on those points, but I am just giving examples that what we are doing in this country, how we are moving forward. But the honorable superior courts have taken certain things very positively. They have changed the whole scenario of the jurisprudence of writing judgments for the litigant, because we are paid by the taxpayers. We are judges because they pay money for us. And I am a judge. I am sitting as a judge in my courtroom having air conditioner facility and everything, because the litigant has to come to that courtroom. It is not for the judge to have that air conditioner into the room. It is for the litigant who will sit there to wait for his turn or then to come to the rostrum. Okay, Dr. Saab, I will talk about something on therapeutic jurisprudence as well. I call it therapeutic lens. Therapeutic lens means you wear a lens. For example, nowadays we say this is a night vision lens. Night vision shows you in the night where the human eye can't see. So the therapeutic jurisprudence have shown us so many things which were available in our laws, but unfortunately they were not. I mean, we as a judges and legal actors were unable to see and read into the law, into the judgments. So when we put the lens, therapeutic lens, we find certain things that help the litigants to understand that the legal and justice system actually works for them. So we say we find healing capacity of laws. For example, for a small example, the probation law, it says that you should not send a person to jail in all circumstances. This is a very good law. A person says, sir, I am sorry. I committed this offense due to certain reasons, but I am sorry. I say sorry. I'm ready to reform. I'm ready to rehabilitate. Kindly help me out. Law is there, but it is seldom used. It is used only for the arms cases or for small narcotic cases of small quantities. in hurt cases, in theft cases, in so many other cases where we can send the person on probation, we generally don't, because we lack, orientation, understanding, training to do this thing, and even the positive impact which it can generate on the society. If I am a convict and then I am sent on probation, whenever you will open the file of the convicts of this country, my name will be there. Amir Munir, Muhammad Amir Munir is a convict. So state's main purpose is resolved. Yes, he is convicted. He done some offense. But then instead of living into the jail, I am living doing some good work for the society as per my probation order. So it helped on, you know, it helped the society from my person out of that conviction. And I am happy because I am not in the jail. I can go for earning for my children, for my society. Then the approach is problem solving. If someone says that this was the problem for which I did this crime, the courts in the modern world now, they are working to solve their problem. It's very strange phenomena that why the court should solve a problem of a person, but it is happening in the juvenile law in Pakistan even. It is happening even in some other laws, some you can say the alternative dispute courts as well, where the people are invited by the judges, they discuss their issue and they try to resolve it out of the court. It is litigant focused. It gives again voice to the litigant. It shows team decision making. When the two neighbors sit together to decide their issue in amicable mode, that helps the society. That helps the economy. Economists will be very happy that you have, made these two as a friends forever out of this dispute. Otherwise, what happens when we decide legally that one person feels I have won the case, the other says I have lost the case. So the grudge comes into his mind. He started or she started, again doing something for the winning part. But here it is a win-win position. You interwoven the society this like this. So they keep on continuing their economic, relationship, their healthy relationship, their societal relationship, their friendship relationship. So a happy society can be a more vibrant society. It is a happy society also, works for happiness of every other person living into that society. But where the society is, fighting with each other, persons are fighting with each other, they have grudges in their mind, they cannot be a good society, and it negatively affects their economy. And I am intentionally focusing on economy time and again, that my judgment or our judgments ultimately affect the economy. No matter my judgment is at my tehsil jadawala where I work, maybe my one single judgment affects the whole country's economy. It will be depending upon the case before me. You can imagine what hell I can create if I am not, looking into all these things. So my mentor, Professor Dr. David B. Wexler, who is professor of University of Arizona as well as University of Puerto Rico, he is father of therapeutic jurisprudence. I will request all the judges, all the future judges, all the lawyers that kindly study and read therapeutic jurisprudence. Literature is available. It is very, very, very helpful for our country to progress, to make our justice system more, you know, you can say quality oriented, more human oriented. And even this therapeutic jurisprudence is in line with the Islamic jurisprudence. I have not seen so far that it it comes into contrast with each other. The ideas discussed in therapeutic jurisprudence are in fact ideas already available in our Islamic jurisprudence. The thing is that we do not understand those ideas in this modern fashion. Okay, we can discuss therapeutic jurisprudence in some other session. Now, Doctor, or my audience, I say that our courts have changed the jurisprudence of this country as far as the language as a medium is concerned, medium of the courts, judgments, and orders is concerned. These are the three important judgments of the Honorable Superior Courts. One came in 2013, so it's almost a decade, 2012 and 2011. Yes, so since last 10 years or so, the Honorable Superior Courts are focusing on this point, that kindly try to write your orders and judgments in your national language. under Article 251 of the Constitution of Pakistan 1973. I will say that as far as the Honorable Superior Courts, like the Honorable High Courts and Honorable Supreme Court, are concerned, yes, the language of the court may be still English. Okay, no problem. But as far as the trial courts are concerned, the law, even in the British times, says that the language of the court is Urdu. This is for Punjab particularly. I need to read the other three provinces. Maybe the people who may be hearing my this speech or my this session, or the judges who were attending my sessions, who had attended my sessions at FJA, Federal Judicial Academy, Islamabad, they must be knowing their own laws that whether this is the situation in their own province as well. But for Punjab, it is very clear. It was in the British time, in I think in 1946, there was a notification that Urdu shall be the language of the court. It is for trial courts, for all the trials, for civil trials, for criminal trials. I don't know why we still try to focus on English language. I myself have tried to write my orders and my judgments in Urdu many a time. And I found that the people appreciate this when they take up the Urdu order instead of English. Now, here in 2020, the Honorable Supreme Court has made a very good judgment for the rape cases. It says all the police officials who investigate the rape cases, because they are police officials and they also don't have very good level of education, and they should be taught all the standard operating procedures of investigation into Urdu language. You know why the Honorable Supreme Court has to say this? Because they understand that there are so many judgments of Honorable Superior Courts, there are laws, there are interpretations of the legal regime about rape cases, and they have found that the ordinary investigating officer working in a tehsil, in a you can say sub district courts, sub district administration level of the police, they do not know that what the Supreme Court or the High Court said about a particular way of investigation, because it was in English. So they say no, change this regime, bring the whole into Urdu language, translate the whole legal system into Urdu for this reason, and communicate this to all the investigation officers so that they can read by themselves and understand that what the way how they have to investigate a rape case. I think this is wonderful. But sir, I don't know that at the moment this has been acted upon, because the judgment came in 2020 and it is only 1 year since there was pandemic as well. Maybe it will take some time to do so, but this is a good way to move forward in this 21st century about the rights of the people, about the rights of the rape victims. Now, with respect to a question of language, I have also seen a judgment where the Honorable Supreme Court has held that a confession was recorded by a magistrate of a person who was not speaking Urdu language. I mean, the Urdu was not his or her language. When the person retracted his confession at some superior court's level, the question came before the court whether the trial magistrate was understanding his language of writing confession. They concluded that the magistrate was unable to understand the language of that accused. So they say it cannot happen. In this judgment in 2015, the Honorable Supreme Court said that the judgments dealing with public interest litigation must be translated in Urdu and must be publicized in that language. A very recent judgment. I just uploaded, updated my presentation. This judgment of Honorable Lahore High Court says that the summons issued to a party must be bilingual. Law says it's in English, but the Honorable High Court now said that the appropriate legislature must decide, to amend the law, that the summons issued to the parties must also be in two languages, the English and then the Urdu, so that any person who is receiving the summons must be knowing that what the court is wanting from that person. The court says write bail orders in small, short bail order. It should not be a lengthy order for bail matter. Now, when we come to focusing on the litigant, we say the Article 2 says Islam shall be the state religion, And Holy Quran says dignity must be protected because Allah says we bestowed dignity on the children of Adam. It's very important Quranic ayat from Surah 17, ayat 70. So if God says that the God being, the creator of this universe says that I bestowed dignity on the persons of Adam and Eve, then how I as a judge or you as an advocate or a teacher or a police officer or any other state functionary can take up that dignity from the person. So it's very high thing when we talk of dignity, and dignity is also in our constitution. And when the people who were studying what the Islam was at the very initial stages, they they published their treaties with the name Higher Objectives of Islamic Law. It concludes that what Islam actually wants. Then what they did, they said Islam needs 6 important values in a society. 6. So I will leave all the 5, but I will focus on protection of dignity. So the early scholars of Islam concluded that Islam needs, wants that dignity of a person should be maintained, should be respected. If you read others, they are also important, but I will talk of dignity. Now, our constitution says that no person shall be deprived of life or liberty, and that dignity of the human being shall be inviolable. Article 14 is the only constitutional fundamental right which is unabridged. It is not subject to any law. I name this article as parent article of other articles of fundamental rights, because all other fundamental rights are subject to law. This is the only fundamental right in the Constitution of Pakistan which is not subject to law. It means it is so prime. So if the dignity is affected by the order or judgment of a judge, he or she is actually violating this article. We should be so much smart while writing our judgments that our words, our conclusions, our analysis, it is not affecting the dignity of any person, maybe directly or indirectly. There should be, all citizens are equal, and there should be no discrimination on the basis of sex. I will talk something about transgenders in some upcoming slides in this respect. Now, you see, the words in the legislature were somewhat offensive, which were actually uh, the drafted and then enacted by the British Parliament. They use the word lunatics, and this word is available in so many British time legislation, colonial legislation in this country now. The Parliament yet need to remove these words from the Code of Criminal Procedure and some other laws. Now, the word lunatic is very well understood in today's fashion that it is offensive. For example, if I say to Dr. Saab, आप पागल हैं, या मैं किसी अपने बहन भाई को किसी को कहूं कि तुम पागल हो, इट्स वेरी ऑफेंसिव. और अगर मैं ये कहूं कि सर और मैम आपको ये ज़हनी प्रॉब्लम है तो हम आपका कोई मैटर रिजॉल्व करने यहाँ पे बैठे हैं, this way of talking, this way of writing will have a good impact on that person, that the system considered my problem, that the system is taking up my problem. The judges, the courts, the lawyers, the legislature, the state, the police, everyone has to see that they should not use the words which are offensive, which directly affect the dignity of a person. We need to change it. We need to change our language. So we need to be more civilized, you can say. So the so this, but what happened? The Lahore High Court rules and orders, they are quite old, maybe 100 years old, or maybe so. At that time, they have mentioned that although persons suffering from unsoundness of mind are described as lunatics in the acts mean the laws, it is now considered more humane to refer to them as mental patients. So the Lahore High Court rules and orders were, at that time the courts were much conscious of this issue. But I still see in the judgments the use of the word lunatic. We need to give much training to the judges, to the advocates, to the police, that kindly, even if a word is available in the law, still you can avoid. You can use a substitute. Use the Google, use the thesaurus. I do this while writing judgment. Sometimes I see this word is not good. I feel that this word may be somewhat offensive. I try to quickly find out on Google that what are the synonyms. Then I find some soft word. This is therapeutic jurisprudence. This is ethic of care. This is how Dr. Wexler has developed the concept of therapeutic jurisprudence, that it helps the litigant with respect to the way the courts, the judges, and other legal actors work for them. And thank God that our jurisprudence was already taking this issue, but I don't know, it was forgotten in the past. Now it has again, came on record. It is now reliving. I will tell you more judgments on this point. 2018 Lahore High Court, page 300. Honorable Mr. Justice Syed Mansoor Ali Shah. His Lordship is now Judge of the Honorable Supreme Court of Pakistan. Very beautiful paragraph. By carefully choosing our words, we can make a tremendous difference in the lives of other youth with disabilities. His Lordship was talking about the people with different abilities, who are disabled, who are unable to walk properly or move properly for some physical, inability or disability. So it is more humane to use the term person with disabilities or persons with different abilities instead of using disabled or crippled, etc. I will show you the word crippled was used in some judgment, and this word was, not found favor in the Honorable Supreme Court, and the Supreme Court deprecated use of this word. Let me see you in upcoming slides. In this judgment of the Honorable Supreme Court, it came in 2020. It affirmed the Asfandyar case just discussed previously. Here, the Honorable Supreme Court again said that human dignity is infringed if a person's life or physical or mental welfare is harmed. So here they say that right of dignity is very important for us. We need to maintain it even in our writings. Writing for the litigant, writing in our judgments. Whatever the word we use, they need to be dignified. So in this judgment, use of pejorative words such as crippled or disabled in the judgment was taken serious note by the Honorable Supreme Court. So this word was actually used by an Honorable High Court. And when the judgment came before the Honorable Supreme Court of Pakistan, they said, kindly don't use this word. It is against Article 14 that deals with dignity and Article 25 that deals with equality. So very important development in our Pakistani jurisprudence for writing judgments. So I request all my judges, my colleagues, brothers, sisters from the trial courts up to the Honorable Supreme Court that this judgment is binding upon us. We need to use the words very carefully. There are some words which at the very first instance don't look undignified. But when the researchers or when the person who is affected by that word reads, he or she feels bad about that. So even judges need to consider their words on the second or third reading of their judgments, that how they can improve those words. They can ask to their friends, to the advocates, that can you pinpoint any word used in my previous orders which you feel is not good or proper, and in any upcoming judgment you can always correct that. No need to correct the previous judgment because we can't do that, but we can do this for future. We should always be open for improvement. To make us relevant, we always need to be adaptive. So if anything is told to us, we should be adaptive to become to be more near to the constitution. A country which is run under the constitution, every person is to follow it. Every person is to apply it. And what to talk of the judges who actually interpret and apply the law? So how we can miss this thing? So I will request all the learned trial courts, my colleagues at district level, that we need to read the constitution at our layer to understand what its provisions actually say. This exercise will help them to re-understand the constitution. In this case of the Honorable Supreme Court, Honorable Mr. Justice Ajadul Hasan, his lordship has written for a mother who came from another country to get the custody of her son. The Honorable Supreme Court has written very beautiful words, And let me quote: the court's consideration that a mother who has arrived from another country to seek custody of her minor children has to face a long litigation, and thus, pending such legal course, she can have custody of her children on interim basis. The treatment given to the mother by the court is exactly what the therapeutic jurisprudence is. Actually, these are not the words of the judgment, these are the words of an article that describe that the Honorable Supreme Court has very plainly written in its judgment for the understanding of the father and the mother that why we are giving the interim custody to the mother. They said it will take long time to decide that issue before the guardian court, so it's better to give custody to the. So this is how they reason. It appeals to your mind, it appeals to my mind, it appeals to the mind of the person against whom that order was made by the Honorable Supreme Court. Now I talk, this is very current issue nowadays in Pakistan since 2018 generally, and particularly since the Honorable Supreme Court took notice of the issue of transgenders in our country. It's in the year 2009 Dr. Aslam Khaki case. In this petition, the Honorable Supreme Court has granted certain, made certain direction to the state institutions to issue national identity cards to the transgenders. They, they directed them to trace the ascendants for the property rights. The Honorable Court directed that the social welfare of the transgenders must be ensured. They should be provided jobs or the businesses. See how the court make itself relevant to the society, to a class of people who is always ignored, to a class of people who is made subject to laughter. The dignity of transgenders it was smashed by this society in recent past. But due to this re-recognition, you can say realization by the justice system, by the courts, and now by other institutions as well, they are now getting their rights. So the Honorable Supreme Court in 2013 at page 188 has deliberated that the rights of the transgenders were fully protected under the Constitution. They say that there should be no confusion that transgenders don't have the rights available to other persons. They say those rights are available because they are citizens. If they are not citizens, even they are persons living in Pakistan. Our fundamental rights say any person living in this country has to be provided those fundamental rights. There are very few rights which are for citizens, but generally rights are for persons in the territory of Pakistan. So even a person who don't have an ID card, a person who is not recognized as a citizen of Pakistan may come to enforce the fundamental right, being a human being, a man, a woman, a child, a transgender, or whatever you may name. So they say participation of the transgender in all walks of life had to be ensured. Transgenders enjoy the same rights under the Constitution. Okay. 2018 Lahore 54. In this judgment again, it is mentioned that the fundamental rights, being human rights, are already embedded into a person. You need not to see that he or she is a male or female or transgender or whatever, a poor, a child. You only need to see that the person is a human being, then you have to enforce those rights if he or she claims. Now for the language, my father who is nowadays ailing, I also request to my audience to pray, to pray for his health. He is paralyzed from right side since last 4 years. He always keep on writing so many things for the law, for the Islam, for other areas. So when he was writing on the judgment writing in Urdu, there was a book presented to him for preface. So he wrote these words in preface to that book, which is titled as Zuban-e Khalq. The compiler is Mr. Sikandar Javed Advocate, who hails from Multan but nowadays practices in High Court, and uh, I mean he wrote this book. He collected all the judgments of honorable superior courts written in Urdu language. So my father wrote as its preface, I quote these words. उर्दू जुबान की अहमियत इसलिए भी बढ़ जाती है कि इस जुबान में लिखे गए फैसलों को समझने के लिए फरीकैन और इनके वकला को किसी दरमियानी जुबान के इस्तेमाल की ज़रूरत नहीं रहती। लिहाजा अदालत और फरीकैन में ये जुबान बराह रास्त मकालमा के लिए बहुत ज़रूरी है। Justice retired Dr. Munir Ahmed. What he says in these Urdu words, he says if we write judgments in the language of the court, I mean Urdu, the litigant will have no third person to make him or her understood that what the order came in his or her favor or or against him or her. He or she can himself read or herself read what the order or judgment is, why the judge reached at this conclusion. So if I say bonjour or qu'il avez-vous, je n'ai pas parlé bien français. So the people who understand the French language, they will be quickly understanding what I asked or what I said. But as far as the person who don't understand French language, they will immediately ask someone, please tell me what Amir Munir is saying. Maybe he has abused us. Maybe he has appreciated us. What he said actually. So when you remove this, okay, the translator has also important role. Maybe the translator is not able to communicate properly the words I uttered from my mouth in the French letters. So the judgment translated to a litigant may not be properly communicated the way the judge wrote his or her words. But if it is in Urdu and the person is reading, he or she may be well understanding the whole. I understand the limitation that some people of this country don't understand Urdu. If we read the Urdu in plain words, they may be asking kindly speak all these words in Sindhi or Balochi or Dari or Pashtun or Saraiki or Pothoari. So this is this is transformation from English to Urdu, which is the constitutional requirement, and I will move little down from here. The transformation must come even up to the local levels. So Punjabi, so Dari, Pashtun, Sindhi, Balochi, Pothohari, maybe other languages of local level which people understand. We need to bring the judgments to that level, but that will be the third tier downstream. At the moment, we need to bring ourselves from English to Urdu, and that will help much. Most of the people understand Urdu at least. I think I may be wrong. So we can do that. Now to bring the change, I also tell my judges, my audience in the judicial academies, kindly formulate your judgment as a short summary at the top of your judgment. So if you write 20 pages in a murder case, you can conclude, you can bring a summary at the top, just like we do academically in our academic research papers. We write 30, 40, 80 pages, then at the top we write abstract or we write summary. I request my judges to kindly write a summary. It must say that in this case, Mr. A or Miss A was alleged to be a murderer or an accused or a defendant of a murder case. After the evidence of the whole, the eyewitnesses have, beyond any reasonable doubt, deposed that he did this murder. So, keeping in view the law on the point, the accused or the defendant has been convicted under this judgment to death sentence or life sentence. This way, the reader of the 20 pages will quickly see that what was the conclusion. Then I say bring some table of contents into the judgments. Judges, in our country, whenever I go to the judicial academies, they make it a matter of fun. Why we make table of contents. We are not writing an article. We are not writing a book. I say no. You are writing something which consists of number of pages. So it's better to add table of contents. That what the page one, what is on page one, what is on page three, what is page eight. For example, if I quickly want to go to the statement of the accused recorded without oath, the table of contents must suggest this. Go to page 8. It will help the reader quickly go there. Headings and signposts. I always say that kindly do this thing. But so far, I am not able to convince my colleagues. Maybe after a number of lectures or the training sessions, and maybe after telling them to read literature time and again, that these things will improve their final product, which is called a judgment or an order. So if they will follow these lines, it will be called a modern judgment, a trendy judgment, a judgment which is quickly, you can go through quickly. For example, I want only to read that in this judgment in which a person has been convicted, what was the motive shown by the judge. So I can only go through the motive part. That's it. It's over. I don't need to read anything else because I only want to read the motive part. I am a researcher, for example. But if I need to read 20 or 30 pages to find out at what page or what para the motive has been discussed, it will, make me like this. Oh, what a judgment. I need to read some 20 pages or maybe. So this is what I want to avoid by suggesting these. And these are not my suggestions. These are authentic. I again refer the Bailey lecture of Lord Newberger. He said this. His lordship said this. Kindly improve your judgments in this fashion. And thank God, the Honorable Supreme Court of Pakistan and Honorable Lahore High Court and even Honorable higher courts of other provinces, I have seen judgments which quote headings. This is very beautiful. I like it. There are many judgments. If you will read those judgments, you will find them quoting proper headings to from start point one to point last. So I request trial judges also to follow this practice. It will add a quality, at least a part of quality to their judgments. I also say to my judges, to my colleagues, trial court judges, that in England, a judge has used a smiley. Imagine he was actually writing for a child, and he thought that the children, when that child will be reading this judgment, I should write him into his or her own level of understanding. Nowadays, children, they use too much of this mobile phone, the cell phone, and they use so many smileys and other things. We also do this while using WhatsApp or other programs. So whenever he has to say the child to smile, he put a smiley there. So when I show this slide to my judges in a Federal Judicial Academy, they again say, oh, if we will use this, our high courts will mind it. I say to them, please don't think like this. If your smiley is well reasoned, the honorable high courts or superior courts will never mind it. They will appreciate it. That for a child or for whatever level you can say, the smiley should be relevant to your order. It should not be irrelevant. It should not be only to show your passion to use smiley. No, it's not the case. It should be relevant, logical, and placement of a smiley to reflect something you want to say in figurative form, because they show more words instead of writing please smile or you should be a smiling face like this. Look at the title of my slide. I write dare to do, because I know most of the judges in our country, they say, no, 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 we will not do it. I have heard this with my ears. You can see the recorded sessions of Federal Judicial Academy where I deliver lecture on this topic. Judges say, no, no, we will not use it. Sorry, our honorable high courts will mind it. I think they will not mind. And I request my honorable superior courts that if any judge will use these things, please consider them as the the relevant development into the society, and use of these smileys at relevant point through reasons should not be taken seriously or negatively toward the trial court. Try to see if the trial judge wanted to be at the level of the person who has to read the judgment and whether this smiley has an impact on his personality while understanding the order of the judgment, then I think the Honorable Superior Court, while following Article 14, and that discrimination cannot be taken on the basis of gender or whatever, they say okay, the judge has used a smiley for a child, and children are using too much of these devices, the computers, the social media and every other thing, and they matter while we communicate nowadays. For example, I can write you, only you for you. So I may be criticized that Amir Munir, you don't know the spellings of you, but the appellate court has to see that why I have written this you only for you, what relevance I have shown. So I think the courts are open. I mean, the constitutional courts are always open to ideas. That's why they develop the law over years. And this is constitutionalism. And this is how our honorable superior courts always do. They keep on adapting to the modern times. We call in Pakistan our constitution as an organic document. I mean, a document which can relive in every upcoming era. In Canada, about the constitutional document, I mean, Act 8 1981, they call it a living tree because the tree, keeps on growing. Likewise, we say it organic document. It is only due to the constitutional judges who interpreted various laws and judgments in new ways. That's why they say it's a living document. So the trial court judges should not be, fearing about use of these smileys if relevant. I will again quote unquote if relevant. They have to show that why they are relevant to be used. So be bold, be firm. This is what I want to. I always say to them, kindly be confident. Have a confidence on your own self. If a judge will remain, I mean, he or she is not confident, then even use of other words may not be relevant. What to talk of using this smiley? So emoji, I think. So I should not do this, but I intentionally did this. The judges in academy asked me, "You have done ever this thing which you are asking us to do?" I said, "Okay, let me show you one thing." Because judges mostly, our judgments are not published. They are not cited as precedents, nor they can be. It is the law of this country. But you can read by getting copies from the parties or by getting copies from the court from where the decision was made. So I am intentionally showing my order to my audience that how I directly addressed a litigant. It's, I mean, I have given all the reference to my order. I was posted at that time in Lahore, and I was hearing family and guardian appeals as a first appellate court. What I did, I directly addressed the minor in simple language and told him into that paragraphs that why this case was filed by your maybe grandparents or your father or or I mean the competing litigants or your mother, whatever was the case, and what happened and why this decision is there. So anyone can read this judgment by getting a copy from this number I have mentioned. I have given the date of the order. So I dared to do. I never know what the Honorable Superior Courts will be doing on this order if it is under challenge before the Honorable Superior Courts. But I don't mind if they guide me that please don't do it. But I believe in myself that if I have done it and if they will appreciate it, it will become a new motorway for the judiciary to follow. Because I have lowered down my way of writing judgments up to the level of a minor. And I did not do this only that I have invented something. I only took inspiration from the literature available online, and that Lord New Berger and the judgments of other judges of the British courts and other courts around the world. When I have read this literature, I did this thing, considering that whatever I am doing, I am not doing against any constitutional command. I am not doing it against any settled judgments of the honorable superior courts which are binding upon me as a trial judge, but I am taking a new way of doing things, considering that I can do it within the domain of my own laws. It is not to challenge any judgment of the Honorable Superior Court or even the Constitution or even the law. It is only the way I approach that litigant through my judgment. I considered my judgment as a means of communication for that person. So this is how I did it. I make it as an example. I quote it as an example to my audience. So I conclude that judgments need to be very simple, written in understandable language, maybe translated to the mother tongue. We need to have audio transcriptions for those who even can't see that what the judge has written. This is not going right now here in our country. We are affecting the dignity rights of those litigants who are unable to see the written words. So we need to have something in audio form so that he or she can understand what has been said about me. And online accessibility over mobile phone, I mean, the judgment should be compatible to be read on online, on the cell phones. And what to talk about if a self-represented litigant is before me? He or she should be given more care in the courtroom. Likewise, when we have to write an order or a judgment, we also need to be very careful while using the words, while telling the whole system, while telling what the evidence was, while analyzing the evidence, and while telling that why I am writing against you or in favor of you. He or she will be not much interested if I am favoring that person. But if I am deciding against that person, he or she will be very interested, very much interested, that why the judge decided against me. I need to convince that person that in the given laws of this country, your act, your behavior, your conduct, your omission, or whatever was before me was not according to the law, and hence you cannot have my judgment in your favor. Some literature on judgment writing I have quoted here, but this is not all. There are so many, I mean, books and articles which can be quoted on this point, and I miss so many things here because I need more time to prepare a bibliography on this point. And let me tell you, my father, who is now ailing, we have started writing a book title. I mean, generally on the title of writing judgments in Urdu. Uh, so let's see when we are able to complete it for our Pakistani audience. So we will be guiding that how the judges can write in Urdu language, what are the barriers, and how those barriers can be, met to write Urdu judgment or Urdu order in proper format, and how to bridge the gap of the terminology available in English, because we are Englishly trained lawyers and judges in Pakistan. We read the law which are available in English. We read the judgments of the superior courts which are in English. So it's difficult for the judges to quickly go to the Urdu mode, and even we are without the infrastructure. I mean, we don't have Urdu stenographers with the court systems. We need, I mean, the courts need much funding from the government to be provided human resources, to be provided English Urdu dictionaries and softwares, so that way the words can quickly be translated from one language to the other, or the system where if I use a word and I want to know that what is the Urdu meaning of this word, the online system should be there to quickly provide a valid Urdu word which is recognized in Pakistani legal system. But the thing is that we need to take first step. To go to the moon, there was first step. Likewise, we cannot make a giant leap. We need to take a small executable step, and then we can have building blocks like this. First block, put another on it, then put another on it. This way we have to move upward, 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 and we will make either a pyramid or a building, or like a tower, like twin towers of like the World Trade Centers or now the Burj Khalifa or something like that. So the thing is that we need to move forward. And whatever I have said in this presentation is not for the judges only who are sitting nowadays on the benches. I am talking all this for the aspirant judges. I am talking all this to my lawyers, my advocates, my attorneys. I am talking all this to the police officers. I am talking all this to the probation officers. I am talking all this to the reclamation officers. I am talking all this to the jail officers. And I am talking to all the economists, the scientists, the social scientists, the physicists, the chemists, the forensics, people in forensics, that we all need to make, a team decision making process to write properly in simple language for the litigant for whom we are writing this judgment or order. I was one day, just to before conclusion, I want it clicked to my mind. I was reading a report, forensic report issued by the Punjab Forensic Science Agency in a murder trial. So what was interesting for me that it was in too much technical language. You can imagine if as a judge I am saying it is too technical, and the person whom I have ordered to be hanged or to remain for his remaining life into the jail, what he or she will be knowing out of that report. If it was difficult to understand by a judge and by the advocate or by the state prosecutor or by the defense counsel. So we also need to lower down the the understanding level of those documents for the litigants. Okay, one report should be in pure technical language. It should be supported by another simplified report for the justice system, for the court and for the litigant. So technicalities to be deliberated by the technical person with the advocates at the higher level, but its simplest form should be available for the litigant to understand that what this means. If a DNA is taken from the you can say the body of a person and it is positive against the accused, it should be very simply written in a support document that why it is so. But those people also need to think and consider that how they can make this thing as a support tool to the judges to write simply, to write in simple format. In the world of, in the whole English world, including America, Canada, England, Australia, New Zealand, there is a movement called simple English movement for the judiciary, for the judges, for the law system. We should also adopt this approach even for the Urdu words, for the Urdu judgments, that there should be a simple Urdu movement. And what we need for the time being a transformatory system where we can simply transform our English into our Urdu product. So there should be Urdu judgments. So conclusions are that the judgment writing is changing its focus toward litigant parties should be made by the judges and everyone. Social context needs to be added to the judgments. Simple language movement should be followed by the judges. New style of writing judgment should be adapted quickly and at the earliest. Art of communication is relevant for the judges and magistrates. The judicial academies must guide judges what is communication, how a thing is properly communicated to the other person. And yes, positively, on positive note, we are teaching this subject to the judges in Punjab Judicial Academy when I was there, and even it is continuing, and the same is happening in the Federal Judicial Academy. And I am sure all other three academies of the Sindh, Punjab, Balochistan, and KPK, they have sessions on this topic, communication technology, how it works for the judges. The relevance of information technology is very important. Nowadays judgment should go directly to the mobile phone, cell phone of the litigant quickly, so that he or she can go through that what is there for him or her. We need to have mobile apps for this purpose. Judges should be adaptive to quickly adopt this technology. They should not wait for something miraculously happening or happen in future. They should do something by their own, whatever they can. So here I conclude, and any question or answer either by my host, my learned friend, and my even mentor, my teacher, Dr. Zubair Abbasi, and any other person who is in the session. Thank you very much.
Thank you very much, Judge Amir Munir. I think that was very, very comprehensive. I think we are over time, so we won't have much time for question and answer. I think your presentation was comprehensive in any case. So in the end, I thank you for your session, and we look forward to welcoming you for our future sessions. Thank you very much, and have a nice day.
Thank you very much, Doctor. Bye bye.